We are frequently faced in our practice with people who have signed what we loosely call non-compete or sometimes non-solicitation agreements with an employer and are now looking to move on. And the question becomes, am I bound by this non-compete? What does it mean for me in terms of taking a new job? Can I ever work again in this area? And the first thing that we need to do is to look very carefully at the wording of the non-compete agreement. These agreements vary greatly in their language, in their scope, both geographical and subject matter, in their time, and all of those factors are things that we look at in determining whether it is likely that a court will uphold a non-compete. And I'm going to add that we have had the experience of the same non-compete agreement being executed by two different employees, each of whom were sued, one in Westchester County and one in another county. And the judges in each case came to a different decision. So it is very hard to predict what a court will do when faced with a non-compete. What I will say, though, is that non-competes are not favored by law. The courts favor an employee's ability to get a job and make a living. And the courts are looking very carefully at the length of time a non-compete exists. A year may be reasonable. 2 and 3 and 5 years may not be reasonable. Courts look at the geographic scope of the non-compete. A 5-mile radius may be reasonable. A 10-mile radius may be reasonable. Maybe a county is reasonable. But nationwide or worldwide may not be reasonable, especially in this global world where people work at home and are working really all over the world. So it is a fact-specific inquiry that we look at, and when we're negotiating such employment agreements containing non-competes on behalf of an employee, we're very careful to attempt to limit the scope of that non-compete if we can possibly do so.